On the record. The time now is 45 minutes past 1 p.m. on this third day of May of the year Lord 2020. This court is now open and on session under Title 20 under Title 28 section Title 28 U.S. Code Section 636 Subchapter Gulf. It's a federal postal court, and this is for the Honorable J. Jesús-Arriaga Abonce and for the Honorable Adelina column Adelina hyphen Arriaga column Pedrosa. And this Corporate United States District Court for the Corporate District of New Mexico. Federal Postal Judge presiding in connection with federal mortgage fraud in the case number on District Court at the Valencia County District Court in New Mexico. Case number Delta dash 1314 dash Charlie Victor dash 201901401. And in connection with the case that we have on federal court, case number 1, column 20 dash Charlie Victor dash 00113 Kilo Golf uppercase space Juliet uppercase Hotel uppercase Romeo uppercase. Under this court-martial under Rule 203, jurisdiction over the offense in relation to the case number Delta 1314 Charlie Victor 201-901-1401, it is clear by now that they have been exposed. A federal mortgage fraud has taken place, and for the Honorable J. Jesús-Arriaga Once was kidnapped from the courthouse when he attempted to file and record the deed. This court has no authority. The lower court has no authority. The moratorium has been violated. Supposedly they have appointed a lawyer from all things on earth, a lawyer to represent for the Honorable J. Jesús-Arriaga Once, who never, ever requested to have a lawyer. For the Honorable J. Jesús-Arriaga Once is a federal postal judge, sui juris, uomo instruito, a special master in common law, mammifero vertebrati, auditor in black law, and a code of banking procedure, and one of the people. I'm the CS2AKB for the all capital name, and I am protected under the Universal Commercial Code 3-402, and I hereby reserve all rights without prejudice under Universal Commercial Code 1-308, 1-103.6, and 1-109. It is on the record. I have to take this minute. I have to take a little bit of some time here before we establish contact with this court, with the lower court, with the supermarket court. Because supposedly this lawyer is supposed to be representing me. Well, I just fired that lawyer, this lawyer. And it is on the record. I have sent you some emails, and these are part of the record. And we're going to be reading this on the record. And it could be after this phone call. The fact that your phone call will end does not mean that this Superior Court of Record proceedings will end. You are now sitting on the witness stand on this Superior Court of Record. And in the United States, in the corporate United States District Court for the Corporate District of New Mexico, you are not sitting at Judge Wapner's or Judge Judy's courtroom, sir, for the record. You are dealing with one of the people, you've been put on lawful notification, and you read English, it is on the record, and you have not replied, you have not presented any challenge, and you have not objected. However, for the Honorable J. Jesús-Arriaga Ponce and for the Honorable Adelina Arriaga Pedrosa are hereby presenting their objection. It's a religious objection, sir. Religious from God. Would you like to interfere with our God beliefs, with our religious beliefs? Well, you'll be in violation. And this is to protect our protective rights and our protective rights to proceed accordingly against all trespassers. And you've been warned on the record, sir. Where rights are protected by the Constitution, there shall be no legislation or rulemaking that shall abrogate them. And I wrote it on the email for you, sir. This is the law, a standing decision, Miranda versus Arizona. The process is unconstitutional, and you know it. If you show up to this meeting, I will have forensic evidence that although I fire you and I never hire you, you still barge and trespass on this criminal investigation in connection with the kidnapping of 2 federal judges and 1 staff sergeant for the United States Army. Do I make myself clear, sir? Do you speak English, sir? If your answer is yes, well, I am hereby charging you with perjury because the documentation in regard to anything and everything that you had to do with this case is not written in English, and it does not contain the language specifications, for the record. For the Honorable J. Jesús-Arriaga Ponce, plead hereby invoke all amendments of the Constitution, and for the Honorable Adelina Arriaga Pedrosa, hereby invoke all amendments of the Constitution, but particularly the 5th, sir, and the 1st. If you don't allow me to speak like you did the last time on the case I read, in which I brought criminal charges of trespassing, it is on the email I sent you over today, sir. And you're in possession of documentation that I asked you this Superior Court of Record requested for you to forward to the lower court. In regard to your dismissal and termination because of your criminal record. And in the case we mentioned in the email, sir, 1 column 20 dash Charlie Victor dash 00113 kilo golf uppercase space Juliet uppercase hotel uppercase Romeo, sir. Your name is on it, and you are a criminal listed in there. How is it that you are going to come and represent the one that is file a criminal complaint in federal court, sir? Can you represent a criminal? Now you're going to have to come up with a criminal, right? Now, under what jurisdiction is that you might be operating? You have no authority. You don't have an oath that satisfies the 6th article of the Constitution. You are in violation of 1 Stat 23, page 1, section 1, sir. Write it down. Rewind this video. Go and read it. You are in violation of Title 4 U.S. Code Section 101. For the record, sir. You were asked to bring those into federal court, and you did not show up, sir. You are operating on delinquency. You are an impostor. You are a terrorist. You are part of this terrorist organization, and you know it. perhaps Chief Justice John Paul Johnson on the corporate United States District Court for the Corporate District of New Mexico will have to agree, or else you are going also to them, with them to Guantanamo, sir, Judge Esquire Johnson. This case is now in front of the Supreme Court and the Congress Oversight Committee. And this case is being filed at the United Nations at the International Court. Is also filed at the Peace Palace as a peace treaty for all of you trespassers to cease fire, cease fire, cease fire, on the name of the National American Red Cross. On the name of the National American Red Cross. You are doing the wrong thing. You are violating my rights. You are attacking a person that is protected by the Geneva IV Conventions of August. Geneva Conventions 4 of August 12, 1949. And Protocol 1 of 1977, June 8 of 1977. Take a moment to go and read. Stop and think that whatever it is that you are operating, you're doing it wrong. Now, if I shall have to come over here and prove my innocence, I hereby demand for it to be in court-martial, and this is court-martial under Title 28, U.S. Code Section 626, Subchapter Gulf, in this federal postal court. In the corporate United States District Court for the Corporate District of New Mexico. And you have the case number. We're going to start, at this point, we're going to start making a phone call, and hopefully, if they let us talk, if we understand your language, if you understand that we hereby plead the Fifth Amendment of the Constitution, and therefore no more questioning shall take place, or else it will be on the record and it is unconstitutional. Now let the record show that this is forensic evidence of the statement herein contained on this record, on this hearing, in which we don't speak your commercial language, in which this hearing, in which Judge Clarence Thomas at the Superior Court for the United States clearly stated that no process shall take even place, it shall take place if the parties do not speak the same language, and therefore this process is not going to proceed. Shall it proceed? Well, it is plain, prima facie, of a constitutional wrong, because if the rights are protected by the Constitution, and you've been warned that the rights are protected for the Constitution, and you proceed still when you were warned, well, now we have forensic evidence. Now, for the lawyers, Brendan McDonald. Under what contract are you operating, sir? Is there a contract that you are operating under? Because for the Honorable Jesús-Arriaga, I won't say has no contract with you. And if you have no contract, then you have no law. And if you have no law, then you have no jurisdiction. But first, you've never been contracted. You're trespassing. Criminal trespassing of this case will send you to the electric chair. And it is on the email. And it's not a joke. This is a real court. This is the People's Court. This is a court-martial under Title 28, Section 626, Subchapter Gulf, under the supervision of the corporate United States District Court to enforce all law, administer the law accordingly against you, all the trespassers. We will continue to attempt to establish contact If not, we are using this video for this very purpose. I will send you an email, Cindy M. Mercer, to tune into this video. And if we are not successful, and it is your duty to come over and witness this video and all videos that I have posted in this case. We have received no challenge. I haven't received your subscription, and you know this on itself is a violation of a u.s.c. due process violation. And we have the federal judge over your shoulder, and over his shoulder we have the Chief Judge for the Supreme Court of the United States for the Honorable John G. Roberts, Jr. Unless you think you want to play with him or you want to go against the standing decision on the Supreme Court for the United States, which will send you directly to Guantanamo. The way it is, Cindy M. Mercer, you got some documents that you took off the record. You're already in violation of Title 18, Section 2071 on the record. Please refer to the video, to this video on September 1st. It's on the record. Yeah, but it is the duty of the Superior Court to serve you with the documentation in regard to any process by law, which you claim you have followed all rules, but in reality, no service has been performed on this case of foreclosure, Cindy Mercer. So, but therefore, this case is bogus. This case does not proceed. And you know it, and you're on the record. And like I said, over your shoulder, you have John Paul Johnson, Chief Justice at the United States District Court for the Corporate District of New Mexico. I mean, you can do whatever you think you can do, but whatever you think you can do doesn't mean that it is lawfully what you can do. And you have to memorize that one because it's two different things. One thing is what the law says, and the other thing is what you may be able to think against what the law says. But at this time, we have you on the record. And we have John Paul Johnson over your shoulder, and over his shoulder, then we'll have somebody else. So now we have dialed here for the record.
Hello, this is Judge Mercer. Who do I have on the phone?
I reserve the Fifth Amendment. I hereby reserve my Fifth Amendment. It is on the record. I am recording. Please don't talk over me. I fire you. I fire all the attorneys, and I have it on an email. Cindy M. Mercer.
The motion was filed today, so I think we should probably wait to get the report back from Dr. Gatling.
Okay, I'm sorry. I was having trouble catching some of what you were saying, so I understood you said something about a motion?
There was a motion that was filed today. We received a copy of it that Mr. Arriaga appears to have filed pro se. That was fairly incomprehensible. I didn't understand it at all. I assume that the copy was sent to the court as well, but I can provide it to everybody. I don't know if that's going to be very helpful. But I think that awaiting Dr. Gatling's report would be the best manner in which to proceed at this point.
All right. So the court will note that the appointment was actually for 4/29. The court will follow up with Dr. Gatling. We do have an email out to him and a telephone message to follow up and see where we're at with regard to the report. As soon as that's received, the court will distribute that. I'll make a note to reset this matter in about 3 weeks to see where we're at and see if the evaluation report's back so that we can go forward with the competency issues on Mr. Arriaga.
Thank you.
Objection. Right. Objection. This is not Mr. Arriaga, for the record. You call me Mr. one more time, and I'm going to charge you with sexual discrimination. The report is not taking place because I have been in contact with someone who does not understand my language.
And we're going to move over to Ronald Arcon Jr., please.
Okay, well,
thank you.
For the record, they have moved on, and this has been reset because they are waiting on the report. Now, the report. Let's talk a little bit about the report. Because it doesn't mean that because the phone call ended, my hearing ended, okay? Now, Your Honor, if the report it's going to be written in a language that for the Honorable J. Jesús-Arriaga speaks and understands. It has to come from someone he spoke to, and the other party also understood the language that for the Honorable J. Jesús-Arriaga Abonce spoke during this attempted interrogatory in violation of the Fifth Amendment. The doctor has no right to come and interview anyone if the Fifth Amendment has been invoked. And by what authority should anyone order an evaluation of someone else when the questioning should have stopped in the first place, on the first time, and the first date that for the Honorable J. Jesús-Arriaga went to court? Now, if the Honorable J. Jesús-Arriaga Abonce went to court and reserved all and invoked all amendments of the Constitution, particularly the Fifth Amendment, on itself, you all should have stopped right that minute. It's plain and simple that you don't know what you're doing. You know, someone inside, in front of Leona. What is her last name? Leona. Some lady that is half judge and half doctor in there. Leona. I was in front of her and I said, "Listen, I don't speak the language. I don't speak the language, and I don't speak the language." And now we have a doctor of psychology in this interview saying, "I don't know what you're talking about." That on itself is forensic evidence. There is a miscommunication here. And so as long as there is not language that is being decided upon, you're going against Clarence Thomas at the Supreme Court for the United States, Cindy M. Mercer. And it is on the record. It is on the record. I wanted to take the authority to start securing all my record because now, as we speak, we conducted the following, and we are going to read the emails for the record. If I took the opportunity to fire this lawyer because I cannot be subjected to juris corpus secundii, and you know it. You know it. Now you're going to have to bring me something that says, or which code, by which code is that you are enforcing. And even if you come up with the code shall not be read to preclude a common law action pursuant the Universal Commercial Code 1-103.6. That's exactly what it reads. Yeah, you're sitting on the bench. You claim to be a judge. Well, please take judicial notice of the fact that we have sent a number of emails, and I am going to take the time to read them because I want them to be on the record. This is what I do best. I will not let anything undone. I will do it by the book, and this is where you will have a problem. Now, I'm interested in what language this report is going to be made, and to whom, or under what authority. Now, I'm commanding this doctor or this pseudo doctor to watch my videos and to subscribe, which I haven't seen, because now this is a sensible matter. This is case law. This is case law. The doctor cannot decide if he didn't speak the language, and therefore he is incompetent to testify. Unless you can override Judge Clarence Thomas at the Supreme Court for the United States, and and do it here on the record, commit perjury here on the record, because this is my proceedings and my proceedings, and this is my venue, and you have no authority. You've been caught, and we're going to continue with this case. It's going to be quite interesting. The mortgage did not exist. You guys have been caught of federal mortgage fraud, and you don't know what to do with it, so you retaliate. You retaliate because now you want out, but in the process, you kidnap this federal postal judge who is yours, and you are being sentenced to the electric chairs by your own acts. By your own acts. By your own acts. On the record. Now, maybe here on the computer. I sent these emails to the lawyer. Oh, you're sending them to me? Oh, okay. And the shameful part is that you are the connoisseur. You've been challenged not only on this. You've been challenged on many cases. I mean, you're disbarred, Cindy. You're not using your real name. You are in violation of 6 CFR 37.3, as it was brought up into the record on the meeting or on the hearing on this case on September 1st. Okay. Now, I send an invitation, or I'm compelling all parties enlisted on the attachment 1 of the criminal complaint to must subscribe to the YouTube channel for the Honorable J. Column JESUS hyphen ARRIAGA column ABONCE, honorable member of the Military Welfare Service and the National American Red Cross, for the trial by record on the video dated September 1st, but although over here I put a video dated April 29th because I wanted all parties to be witnessing the fact that the doctor does not speak my language. The doctor said it. You can see the doctor on video saying, I don't understand what you're talking about. That's all I wanted to know, doctor. And at some point you decided that you'll be wasting your time. They'll be wasting their time because I don't speak their language and nobody speaks my language. So, be aware that this decision is on the record. Now, you're going against it, you agree with them, then of course it will be on the record. You will be charged with collusion to the same crime, the same constitutional wrong. And I cannot say it enough. Honorable member of the Military Welfare Service and the National American Red Cross. Now, since when you can attack this Military Welfare Service, sir? Under what jurisdiction? Under what jurisdiction can you barge in an office of the Welfare Service and say, hey, here, you have to do this? You have to have an authority. Doctor, I think you need psychiatrical help. Because if you were capacitated on this field, first you need an authorization for treatment, correct? Do you have an authorization for treatment? And the answer is no, I never gave you any authorization for treatment. And it is on the record. Now, we're going to continue with this because and you were told that it is unconstitutional, and you say you understood that part. But if you continue and you do it unconstitutionally, it'll be on the record. You are acting unconstitutionally willingly, even if you knew when you admitted that it will be unconstitutional. Now, in what language are you going to write this this report, doctor? And onto what name? Because the name you have in there is not for the Honorable Jesús-Arriaga Ponce's name. And you have to prove it. I mean, I give you the opportunity. I say, for the Honorable J. Jesús-Arriaga, I won't say that is not the name. Which would you wish to withdraw your statement, sir? And you did not. So now, if you're bringing false and misleading information or representations into the record in violation of Title 15, Section 1692E, you were given the opportunity to withdraw, and you still continue on that path, doctor. That means you need psychological help, because you are sending yourself to Guantanamo for the remaining part of your natural life by your own actions, doctor. People's lives are at stake over here, doctor. You know, you're not going to say, well, I made an evaluation, I didn't speak the guy language, but hey, he's good to go. Crush him, hang him to the wall. Apply the law that does not belong to them. Apply the law that does not belong to people. I ask you, doctor, would you agree that corporate law is self-defining? And here's the best part. If you didn't agree, doctor, at least you didn't disagree. So either way. And if you disagree that corporate law is self-defining, wouldn't you need to go and get a psychological evaluation? Well, geez, doctor, it don't sound like you went to school for a long time, and whatever you did learn is not clear to anyone what it is that you do, since you wouldn't even be able to define or give us the definition or the correct definition of the word psychologist. Now, in one of our previous videos, we have the Constitution, and I'm going to refer you that you go and watch the entire video, because I want to be fair to you, doctor. You went to college. You seem to be like a very well-educated person who can read and comprehend the Constitution, doctor. And then this is going to be a quite interesting document for you to write a report. And then the best part, you know, we agreed that you were going to do it on Nahuatl. Although you said, I don't know what you're talking about. Well, it's on the record, doctor. If you don't know what it's all about, and you ask to be performing a language that you know nothing about, well, now we have you, doctor, as forensic evidence. Isn't that nice and wonderful? That we have the doctor as forensic evidence that he couldn't perform because he didn't speak the language. Well, under the same principle, Cindy Mercer, under the same principle, I know that you guys don't allow people to talk, and that's violation. I'm hereby charging you with violation of the First Amendment, and the Second, and the Third, and the Fourth, on the Fifth, and the Sixth, and the Seventh, and the Eighth, and the 11th, and the 13th, and the 14th, and the 15th, to say a few, Cindy Mercer, and all of you judges involved in this terrorist attack. Because now we have someone whose superior knowledge of the law cannot be questioned, and that is for the Honorable John Paul Johnson, Chief Justice for the Corporate United States District Court on the Corporate District for the Corporate District of New Mexico. Do you, sir? Do you agree? Then you should have to agree, right? Well, you're here by command to perform and administer the law and act upon ministerial duty on the witnessing of a constitutional wrong, or become compounded to the same constitutional wrong for the malfeasance, misfeasance, or nonfeasance, right? And violation of Title 42, Chief Judge. Title 42, Section 1986, sir. You see a crime, you stop a crime. You see a crime, you stop a crime. Correct? Now you have to say yes, Judge. Come on, are you going to tell me no? Now, where rights are secure by the Constitution, there shall be no legislation or rulemaking that shall abrogate them, correct? Miranda versus Arizona. You're familiar with that, don't you, Judge? Are you going to go against that one, Judge? Because now, over you, Judge, I have John G. Roberts Jr., right? And same question goes to you, John G. Roberts Jr. Where rights are secured by the Constitution, there shall be no legislation or rulemaking that shall abrogate them. Miranda versus Arizona. Now tell me, can you proceed? Well, I'm interested. Doctor, I'm not giving you the authorization to violate my right of privacy. If you go and talk to the court saying that you spoke and you share any of that information with them in regard to anything is it did what we spoke, and you want to be clear that my medical records or anything relating is part of my right of privacy. And I'm going to say it again. Sir. You have no authority. John Gatlin, you have no authority. You are not a doctor. You are not a practitioner. You're in violation of Title 4, Section 101. You're not using your real name, and this is a legal proceeding. You are concealing identity. And in all legal matters, all legal names have to be used, and you are not using your legal name. I ask you, please state your full given name for the record, and that's not your full given name. I don't believe it's your full given name. Is this how it appears in your certificate of live birth? Because I'm going to ask you to bring it over for the record. But if it's not, well, now we have evidence that you are practicing under a fictitious name. I ask you if you're a corporation, and you deny. You say you're a practitioner. I ask you for the Honorable J. Jesús-Arriaga. I want to ask the Dr. John Gatlin if he had license to practice on New Mexico, and you say yes, that's affirmative. Well, let me emphasize, for the Honorable J. Jesús-Arriaga, I won't say is not the state of New Mexico. It's a human being. And you have no authorization to interact with human beings. If so, by what authority? How can I get and interact with part of your family that I have no authority to interact with? Yes, trespassing. I'm charging you with trespassing and bringing false and misleading information and representations into the record. In violation of Title 15, Section 1692E, sir. Put it in your mind. You are guilty. And then plus is perjury. I warn you. One perjury for you, doctor, is the death sentence. I nearly died on 18 days. They had me in there on a hunger strike. I was kidnapped. No charges. At this point, no charges. I plead the Fifth Amendment 5 times. And today I pleaded again for the 6th time, sir. How many times do you have to plead that amendment for the questioning to stop? It is obvious by now that whatever it is that you might be able, you still want to share, or or the court is waiting for your report. The report itself is going to be evidence of trespassing, and you're going to be charged with criminal trespassing and in trespassing on a case. I gave you no authorization, and I preclude you hereby to share with anyone any of my information. For the record, sir. I will use this video as forensic evidence, and you are compelled to watch this video, doctor. You're not going to go and turn the other way, and you're hereby warned that whatever report you write, it has to be in a language that I speak, and we agree on Nahuatl. And we also say that you always try, that you people always send in documents in the scripta continua, and this is the scripta continua that I wanted up on. Nahuatl, sir. Or else it's not going to happen. And you probably never thought that you were going to be up in a situation in which you're going to have to do this, right? Okay, well, let's continue here with the emails, okay? Okay. Now, must subscribe to the YouTube channel for the Honorable J. column Jesús-Arriaga column Avonce, Honorable Member of the Military Welfare Service and the National American Red Cross for the trial by record. Video dated April 29, 2021 is on the record. Now, to John Duran and Brendan McDonald. Warning to John Duran and Brendan McDonald. Let the record show of your dismissal pending terrorist act and kidnapping a federal postal judge, I juries, and one of the people. Now, you show on the hearing on May 3, 2021, on a criminal trespass, this court will issue this forensic evidence unto the U.S. Marshal's Office is hereby compelled to act upon a ministerial duty on the witnessing of a constitutional wrong or compound to the same constitutional wrong now under Title 42, 1986, you see a crime, you stop a crime. See, if you don't forward these emails, sir, if you don't forward these emails to the U.S. Marshal's Office, you will be in violation of Title 42, 1986 on the record. And this Chief Justice John Paul Johnson will have to execute this order. It is on the record, sir. Oh, nada más hay uno. Let me see. And maybe here we can see. Okay. Okay. Bueno. Oh, estaba en el mensaje. Okay. Okay. Well, thank you. Okay. This is real-time video, so this thing is bound to happen. This is not act or recorded. This is real-time video. And I guess we were this, but we're going to read it again. We've sent you the lawful notification, and we also send you this document here. And with this Superior Court of Record under Title 28 U.S. Code, Section 636, Subchapter G, Golf, Court Martial Rule 203, jurisdiction over the offense to John Duran and Brendan McDonald have been served on this 3rd day of May 2021. Please alert the inferior court of record your dismissal pending the criminal charges filed on the aforementioned case in connection with the kidnapping and torture of a tribal governor, Nahuatl federal postal judge, I juries, and one of the people. Forward the court all emails or be charged on the record with violation to Title 18 U.S. Code Section 2071. And you received this mail today, sir. and it was forwarded to you, and you received it. And it is on the record. We are going to we are going to refer you to the First Amendment of the Constitution, and read all the amendments that we mentioned that you are at breach. I could go and look for them over here and read them for you, which I did, or I could do if I had time, but I don't have time. So now it is on the record. On this May 3rd of the year, Lord, 2020, that the proceedings are going to start over here. Well, let me see if I can contact the title insurance. Maybe we can give him a call since we are here on the record and see what is their position in the claim that we had. And we had sent them an email, so now we have an attorney. Maybe we can use this opportunity to bring him as a third-party defendant, because maybe they can keep us informed about what is going on with our claim in regard to the insurance of title. Now, if I went into the 10 amendments of the Constitution, you don't need to know much. The bottom line is you don't let me talk. Hey, you're done, unconstitutional. You're going to Guantanamo. You don't have to go and have more than a certain amount of amendments to be broken on for it to be effective. You break one, you're done. You're done. And I was placed on mute. I was placed on mute for the record. It's a violation of the First Amendment and constitutional. Now, plus they don't even speak my language, and then they have a lawyer that I had fired, but he still showed up, and he says, well, you know, Mr. Arriaga wants to go proceed. Now, for the record, sir, you call me Mr. one more time, I'm charging you with the sexual discrimination. And it's on the record. I'm not to be referred to as sir. And for the Honorable Adelina Arriaga Pedrosa, is not to be referred to as ma'am. So you don't have that phone number for the Devon lady? Maybe I can look for it here. I think she's got the number in there. I believe there is a number. She says, no, okay, well, we don't have the phone number. But if we write her up a note, we're gonna send her to watch all these videos in regard to this federal mortgage, federal fraud of mortgage fraud, because this mortgage did never exist. Now, on one side, Cindy Mercer, we have a bank saying they have no interest, and then if you go into the insurance company, there is no mortgagee. Now, these documents are in our name, and you know it. Are they being filed in the court on exactly on that one day, that March 17th, when you kidnapped for the Honorable Jesús-Arriaga once? You know, is this what happens really here on the United States? They come and try to take your property without any jurisdiction, without any regard for the law. And if you go trying to straighten this up, they throw you on confinement for 18 days without any medicine or cold water to drink. They throw you in there in violation of your protective rights when you already have protected your protective rights. They throw you in there for 18 days, no phone calls. No phone calls. It's clear evidence, and it is on the record, and I have you on the record. You speak a language I don't speak. I speak a language you don't speak. You fudofo nofo what the fuck right? Efes, kefe, nofos, efe, defe, kefe, mefe, afa, lafas. Mefen, tiefen, defes. ¿Verdad que no? ¿Verdad que no me entiende la señora? Entonces vamos a hacer algo. Si usted no me entiende, ¿yo por qué le tengo que entender a usted? ¿O bajo qué autoridad? Si usted no me entiende, yo no le entiendo. Y si no nos entendemos, bueno, pues no nos entendemos. Pero la ley dice que nos tenemos que entender, ¿right? Y si usted no habla mi idioma, yo no hablo su idioma, entonces, ¿qué es lo que estamos aquí? You want to go against Clarence Thomas? Cindy M. Mercer? That guy will throw you into Guantanamo. Know it. Read it. What kind of deals have you made with this with the Supreme Court that you're going to violate the law and they're not going to say anything? Do you have a deal? Do you have a treaty? No, you don't. Do you have a verified claim? No, you don't. Do you have any authority? No, you don't. Do you have any jurisdiction? No, you don't. Do you have a contract? No, you don't. Do you have the right name? No, you don't. Do you speak my language? No, you don't. Do I speak your language? No, I don't. It is clear, forensic evidence, that the commercial language, it is a fictitious language. Can I force you to speak a fictitious language? No, I'm not. I cannot. Under what jurisdiction, right? Know it. Put it in your brain. I mean, it's time to wake up. You are being watched by John Paul Johnson. John Paul Johnson, you have a book in your library that says exactly this, and it is Miranda versus Arizona, sir. Do you agree? Go get that book and read it to Cindy Mercer and tell her, hey, you don't do this because you go to Guantanamo. Now on, you're being commanded to follow and execute the law. Execute the law against these trespassers. See, I don't have the power to execute your law, but you do. I have the power to execute my law, and under my law, Cindy Mercer and all these trespassers are going to Guantanamo because you are going to send them to Guantanamo. If you don't do it, oh, well, then John G. Roberts is watching you. If John G. Roberts at the Supreme Court of Supreme Court for the United States doesn't do it, oh, well, he's being watched by the International Court. There is 9 judges over there, 9 judges, and they're all neutral, and they're from all parts of the world, and they will not agree with you. They will not agree with you, sir. There is the International Committee for the Red Cross watching you. How is it that you can get away with it? This video evidence is forensic evidence that you are doing the wrong thing, that you know it, and that you have no regard that in this very meeting, in this very hearing, or whatever you want to call it, I plead the Fifth Amendment. That's all I said. I plead the Fifth Amendment. Now, this lawyer here is talking and saying that Mr. Arriaga wants to go pro se. Well, now you're going to have to come up with the evidence, sir, because I never mentioned the word P-R-O-S-E. P-R-O means no. And S-E is to say. Not to say. So I said, I wanna be no say. You are hereby charged with bringing false and misleading representations into the record in violation of Title 15, Section 1692E, sir. In my emails, when did I say, in my entire communication of emails, when did I say I want to go pro se? I said I will attend on my own. You are being charged with perjury. 15,000 and 15 years in jail, sir. And it is on the record. You come over here and speak, and I told you, if you showed up to this meeting, now I have forensic evidence to put you away, and I'm passing it on to this U.S. Marshal. So now it's forced, as forcibly. Oh yeah, I'm your lawyer, regardless you like it or not. Under what authority, sir? Under what code? You guys are plain idiots. All of you judges, all of you lawyers are just ignoring it. But you ignore it here. Here's the one thing, okay? You should have known that you cannot do that. If you did not know, well, then that's negligence. But you lose either way, because if you knew, it's willful tort of malpractice, and your insurance is watching you. And I have the emails that I'm going to send your insurance and say, look at your lawyer, what he's doing. Look what he's doing over here. He was told not to do it, and you were told you're going to be sent to the electric chair, and you are sent to the electric chair. If I came over here and to your home and I violated one of your kids, of course I get violated. I get sent to the electric chair, right? Well, this is no different, sir. You are violating and you are trespassing on my case, and you're obstructing a criminal investigation in connection with the kidnapping of two federal judges, sui juris, and one of the people, and a staff sergeant for the United States Armed Forces. Do you think you can interrupt that? I wouldn't want to have that in my record. But you have interrupted, you have barged, you have trespassed. You were told not to do that. If you speak my language, but if you did not understand, well, you can go over there and say, oh, I did not speak his language. I did not understood his language, and therefore I still win because I don't know your language. You don't know my language. What's going on, guys? What's going on? You are at a loss. You are a criminal. I file a claim under the Terrorist Act on the insurance for the state of New Mexico. The state of New Mexico does not exist. It's bringing me false and misleading representations. Where is the damaged party? And how can you proceed in a language that I don't speak? And I tell you. And now, how can you proceed if I reserve my rights? And if I invoke all amendments of the Constitution and I invoke the Fifth, how can you proceed? You guys are too much. I mean, you know, the world is watching, you know. I mean, what does this John Paul Johnson say? That you are doing great? And if he says that, well, what is John G. Roberts going to say? That you're doing great? And if he says that you're doing great, what is the international court where 9 judges, and that are neutral judges, are going to be making an analysis of your performance or your poor performance of the law? You're not even practical. You're not even following the law. I never dealt with a bunch of idiots before like you, like all of you. I run a successful business helping others. I make it my business. I dedicated my life to go on aid of the sick and wounded of the military, and you are all military. And I was looking after your family when you were deployed. Is this the treatment you get when you are from the Red Cross? Somebody here better start doing something about it. Somebody here better start doing something about it, because you know what? This is getting to be too much. When do you stop? What do you need? You kidnap one of the people from the National American Red Cross, an honorable member of the Military Welfare Service. You kidnap him and you exchange him for money, and you wanted cash. And then when the ransom was to be paid, you change your mind and say, no, I want a money order. Now, for the Honorable Adelina Arriaga Pedrosa is also from the Red Cross, and you say she could not pay the ransom because you could not call another member of the Red Cross to get the ransom, right? Well, somebody from the state of New Mexico has come over to pay the ransom. and it's on the record. Now, I was going to to read the cover of this document at UNM Hospital, where for the Honorable J. Jesús-Arriaga was rescued from the Valencia County Detention Center, and his cell number was Alpha 201, and this is by the American Medical Response Albuquerque, and it says here that they were called. They were departed from Los Lentes Road. And they were called on an emergency, and the response was made to the Law Correctional Facility. And the response mode was with lights and siren. For the Honorable J. Jesús-Arriaga was having seizures by day 11. Seizures. Diabetic seizures. His oxygen had dropped to 85. He was placed on 4 liters of oxygen. There is the heart rate was down to 45, and it is on the record. You know, this is a crime on video. This is exactly how it happened. Now we're going to go down into the detail, read some more about this, but for the time being, I'm going to refer you, doctor, to watch the video of the Constitutional. To you lawyers, you've been fired, and I never say that I wanted to be pro se, because I am not accepting or understanding any charges. In fact, I don't speak the language. Why would I say that I want to be there pro se if I don't speak the language? You are hereby charging with count 2 of bringing false and misleading representations into the record in violation of Title 18, Title 15, Section 1692, lowercase echo, and lowercase f. Unfair and deceiving practices. You're deceiving. You are deceiving. You should be ashamed of you. Your parents should be ashamed of you. They were all proud of you when you were going to go to law school, and then you went over there to law school to learn how to become who you are today, bringing false and misleading statements and representations into the record in violation of Title 15, Section 1692E, while you knew it. You are compounding to this kidnap. You are hereby charged, sir, with the compounding of kidnapping and torture of 2 federal judges and 1 staff sergeant of the United States Army. And it is on the record. You have no business. You cannot practice. You have criminal charges. You were instructed to send these emails to the court on the record, and if you haven't, well, now I have forensic evidence, and it's enough to proceed to get you arrested. The U.S. Marshal is hereby commanded to act up in a ministerial duty in the witnessing of a unconstitutional wrong, or become compounded to the same constitutional wrong. And I'm asking you, attorneys, I'm asking This Superior Court of Record is asking John Duran and Brendan McDonald to turn yourself into the marshal's office for a sentence of life in prison, and if you run or go away and you don't turn yourself in, you'll be commuting your sentence into the death penalty by electrocution on the electric chair. And it is on the record. And for the U.S. Marshal, you are here hereby compelled to act up in a ministerial duty and the witnessing of a constitutional wrong or become compounded to the same constitutional wrong on this May 3rd of the year load 2021, 50 minutes past 2 p.m. It's on the record. We're going to be posting another video where I'm going to start bringing documentation, and we're going to bring the title company. So for the time being, it is on the record, and I'm sending Judge Cindy M. Mercer an email to come and watch this video. And we are signing out for this. However, this court will always be on session under Title 28 U.S. Code, Section 636, Subchapter Golf, in this court martial, and Rule 203, jurisdiction over the offense, and it is on the record. Thank you.